Hey everybody, it's Yoli Medina, and I'm going to be talking about the Kohberger case. This is the defendant who is alleged to have committed the four unalivings of the four students in Idaho, and it's Maddie Mogan, Kaylee Gonsalves, Anna Coronado, and Ethan Chapin. And they were brutally murdered. And Brian Kohberger is going to be standing trial in the middle of August for these crimes. And his attorneys and Brian Kohberger presented evidence to allege or to be able to assert the alternate perpetrator defense, meaning that they have proof that somebody else did it. It's a very high standard, and I wanted to go over it. I know a lot of channels have gone over it, and I think for the most part, I think the gist of it is that the court is not going to entertain that motion or grant that motion at this time. And I'll show you what I mean. So here is the redacted order on defendant's offer of proof regarding alternate perpetrators. And so I'm not going to read everything, but there's the highlighted text, and it says the court concludes that at this time, defendant's alternate perpetrator proffer is inadmissible under Meister, as it is irrelevant or excluded by Idaho Rules of Evidence 403. However, this does not foreclose defendant from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on possible leads. Okay, so the court goes through an analysis, which I'm not going to go through. But what I do want to say is that it appears that the evidence, or I shouldn't say evidence, the information that was provided to the court by Kohberger's attorneys consists of inadmissible hearsay. And this is in the first footnote of this order. It says here, I'm not going to read the footnote. The last sentence in page 2 says, here the evidence defendant has offered purporting to establish the four individuals as alternate perpetrators abjectly fails to meet the Meister standard. And then there's a footnote, number 1. It says, in addition, the evidence largely consists of inadmissible hearsay. Defendant contends, however, that under Chambers v. Mississippi 410 U.S. 284, 1973, hearsay tending to establish third-party culpability may be admissible. And bear with me while I go to the other foot. Okay. Then it says, may be admissible to protect a defendant's constitutional right to a fair trial and present a defense under the 6th and 14th Amendments. The court goes on to say that what Chambers actually held is that an accused has a due process right to the admission of exculpatory hearsay, i.e., a confession by a third party, provided it is accompanied by persuasive assurances of trustworthiness. And I did want to talk about that because I thought in my mind that this, the information that would be provided to the court would be hearsay. It would be somebody saying either I did it and somebody capturing this or somebody hearing this. And that would be an admission against interest if somebody said that, because why would they say that? But in this particular case, we have somebody who is charged, and that is Kohberger. And the reason why that wouldn't work in this particular case is because anybody could come out and say, I did it. And there would have to be corroborating evidence that that person did it. Otherwise, a defendant could pay somebody to say they did it, and there'd be no evidence and it not be proven at trial. Even though they admitted it, they're going to say, well, I admitted it, but I didn't mean it. So, I mean, you can't just go by what somebody says. Now, there has to be corroborating evidence. Now, I don't know if the corroborating evidence was not able to be obtained before the hearing on this motion to present the defense of alternate perpetrator. I don't know that. And there's so much that is redacted here that I have no idea. But for the most part, if we go to the end, of the order, it says, the highlighted area, he says, he may inquire as to the reasonableness of the investigation, including investigating and ruling out other leads. He is not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. So I think most people who are covering this case, they pretty much caught on to that language. He denied it now for the time being. So I wanted to point that out. And I also wanted to point out that in Idaho, it seems that there are a lot of confidential informants in that area. As we've seen with the DoorDash driver who might be a confidential informant for other cases aside from the Kohberger case. I don't know that for sure. But it seems to be that there's a big drug problem there. And the state or the local law enforcement use confidential informants in that area, the Pullman, Washington, and Moscow, Idaho area. And I would think that they are using them because that's a major area, allegedly, where there is trafficking of rugs. And so somebody, I believe, may have spoken about this case and said either I know who did it and it's this person, or maybe even there's a confession. But again, it has to be corroborated with evidence because the trustworthiness of it, and the court in the document talked about the trustworthiness of the information. And the trustworthiness is always going to be scrutinized because we are a month and a half before trial. And now the defense is providing this information based on newly discovered information. And we don't know what that information is. We only know that the bulk of it, the majority of it, is hearsay. And that's pursuant to what the judge has stated in the papers. But one other thing, and that bothered me about, well, not one other thing, but what bothered me about this written order is, and let me share it again, is the court in footnote 3 made a point of saying the fact that these individuals live within walking distance to the crime scene is not probative evidence, and probative just means that it's evidence to prove more likely than not. So I'll read it again. The fact that these individuals live within walking distance to the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. Now, we as a public, we don't know that for sure. We only know that there was a white Hyundai Elantra. If it was a white Hyundai Elantra, you need an expert to identify the car. You can't look at it with your naked eyes and say it's a Hyundai Elantra. You need actually experts who are going to tell you that it's a white Hyundai Elantra. So we don't know that this person drove a white Hyundai Elantra or drove a car, for that matter, to the crime scene. So why he says that is interesting to me, because either he is spilling out evidence that he may know of that is sealed at the moment, and he is saying that the evidence shows that the perpetrator drove a vehicle to the crime scene. I don't know why he would say that. either he's spilling out something that he knows, or he is saying that he believes that the perpetrator drove a vehicle to the crime scene, and so therefore that these people lived within walking distance is irrelevant. That to me is strange. And then it says further, none of these individuals drove a vehicle matching the description of the suspected unaliver. And I don't know, it seems that the judge is making a statement that the defendant drove there. But even though he's making a finding of fact, it's in a footnote. And I guarantee you, the jury is not going to be instructed that you must accept that the perpetrator drove a vehicle to the crime scene. That's not going to be a jury instruction. So this superfluous footnote here, I don't know why he put that there. It's enough to say that whatever evidence was produced that was mainly hearsay is just not admissible. It's not reliable. And the reason being is because anybody can say, oh, I did it just to create, an alternate perpetrator defense, and then, oh, but prove it. And that doesn't work well, because it can't be admissible, because it's not reliable. You have to have evidence supporting a confession. At least that's my understanding of the law in Idaho. I could be wrong, but at least that's my understanding. It's very hard to prove that to provide an alternate perpetrator defense. It has to be proved with evidence that is admissible to a court. And some people might say, well, it should be admissible. I don't know why it's not. But in reality, the law is the law. And when you can't meet the threshold of admissibility because it's hearsay, there's no reason to go further and say it's irrelevant. I think that the fact that it's an inadmissible hearsay and not reliable is enough. So the fact that the judge went beyond that and said it's irrelevant kind of left a bad taste in my mouth. But because anybody who lived near that area, it's relevant, okay? Unless you're absolutely convinced that the perpetrator drove a car there. So it's very confusing to me, this order, but I understand it in a sense that the judge said that it was primarily, the bulk of it was hearsay, and it was inadmissible hearsay. So somebody said something, and we don't know who, because everything's sealed. But, when everything's sealed, it makes it very difficult for people to try to understand how someone's being prosecuted. And that's my issue, is we don't understand how someone's being prosecuted, and the public has a right to know. And despite what other people may say, yes, okay, maybe we don't need to know everything, but the general rule is that the public has a right to know how people are prosecuted. There's some exceptions, like national security, where things will be sealed. But also, I think the use of confidential informants in the Moscow, Idaho, Pullman, Washington area might be overused. And that's just an opinion that I'm making, because the use of undercover agents, because those are the times when you would want to keep things sealed. And it could be that. But at the same time, when the judge, I covered this way before, when the judge made a ruling that things should not be arbitrarily sealed or presumed sealed when you file something in this case. When the prosecutor or the defense files things in this case, there should be good cause for it to be sealed. So the fact that the media is on this case is not an excuse, because as you know, or as you may have heard, the court denied the trial continuance based on that, and also based on the fact that Ann Taylor couldn't get her mitigating expert witnesses to get enough information. But so the sealing can't just be because of the media, because if that's the case, then the judge is talking out of both sides of his mouth, because he's saying basically, I'm not going to continue the trial because of the media, but we're going to seal it because of the media. Well, if the media is the media, they're gonna talk about it no matter what. So why seal? Why seal the information? It's up to the attorneys, the defense attorney and the prosecution, to pick jurors who they have an opportunity to grill these potential jurors to find those that are not biased. And attorneys are trained in doing that. It's something that you're trained to do to elicit bias and get those jurors removed because of cause. So I'm a little confused as to why the judge made that finding in that footnote about the perpetrator driving to the scene. And that is going to be a jury question, because like I said, I don't think there's going to be a jury instruction that says, jurors, you must assume or you must accept the fact that that the perpetrator drove to the house. There isn't going to be a jury instruction like that. At least I hope not. Those are my thoughts on that. And then the other, the amended scheduling order, the judge basically continued the trial for about a week or so. And that, people are confused. They're saying, well, he continued it. Why doesn't he just say it instead of saying it's denied and then moving it, a few days or a week, behind, from the original start date? Well, in California, there's such a thing as trailing. And when you go and report for trial, you may not start that day. You're trailing. In other words, you're waiting to see if a courtroom opens, or you're trailing until a decision is made by the judge on certain things. I don't know what it's called in Idaho, and I don't know if this is the case in Idaho, but in California, I would think this was like trailing. You're trailing. You're still set for trial, but you're trailing pending something. And what I wanted to show is the court's amended scheduling order. Let me see if I can. Okay. So the court's amended scheduling order number 1 says, sealed proceedings with the court and counsel will take place on July 28th, 2025 through August 1st, 2025. So we're not talking about a day or 2 days. We're talking about multiple days. And the way the court writes this order, it says sealed proceedings. So I'm not sure if that is sealed hearings with the court, because on the court website or the case summary, I believe it says hearings. But if it's proceedings, it might be a different issue. So I know that when Ann Taylor brought the motion to suppress regarding, or actually it was the prosecution that brought the motion to suppress any reference to the AT&T timing advance records regarding Kohberger's phone, the defense opposed that and said basically that was a controversial affidavit by Cy Ray saying these records would have been available. They should be produced. There's no reason why the prosecution doesn't have them. And he made certain accusations. So what the judge ruled on was that Ann Taylor, the defense attorney, would be able to cross-examine one of the FBI agents regarding the timing advance records before the trial and outside of the jury. So I would think that that's what these proceedings are. But you're not going to take 4 or 5 days to cross-examine an FBI agent on the timing and advance records for Brian Kohberger, whether they were available or whether they were obtained, and why didn't they produce them to the other side, to the defense. So I feel like there's more to this regarding this number of days before trial that is going to be sealed. But again, the sealed portion is very troubling to me. And because again, if the government, and I say government because there was 3 agencies involved. There was the Idaho State Police, Moscow, Idaho Police, and the FBI involved in this case. If they did something wrong or they withheld something, are we going to know about it? And is it just going to be this sealed hearing and there's going to be no outcome? I mean, it doesn't even say what the sealed hearing is about or sealed proceedings. I mean, I can guess that part of it is going to be the cross-examination of the FBI agent regarding the AT&T timing advance records, but the rest, I have no idea. And it's sealed. And so shutting out the public like this is dangerous because, the public does have a right to know. Not every single detail, but it does have a right to know about certain major events happening in somebody who's facing the death penalty or even facing any kind of criminal charge. And so those are my thoughts on this. And I also did a show with Andrew Myers, Law Offices of Andrew Myers, with Lucky, Unfiltered Lucky, who's covering this case as well. And I don't have the link to it right now, but I'll post the show when it comes out tomorrow. Today is, it'll come out tomorrow, and this video will probably come out tonight. So those are my thoughts, and I have concerns. And I think people should look at this from the standpoint of having sealed information and being able to follow a case, because what secret prosecutions are not supposed to happen in this country unless it's a matter of national security or some other type of security measures, or I don't know what's going on in Moscow, Idaho, but they do have that rule. It's an administrative rule that allows them to seal certain things for certain reasons. And I mean, those are just my thoughts. Let me know what you think.